hold her from obligation to obey the Constitution of the United States, or take away the power of Congress to punish his disobedience, end quote. Id at 348. The court then addressed the judge's argument that the court lacked the authority to punish a state judge for, quote, his official acts, end quote. Its response was twofold. First, the court described juror selection as, quote, merely a ministerial act, as much so as the act of a sheriff holding an execution in determining upon what piece of property he will make a levy, or the act of the roadmaster in selecting laborers to work upon the roads, end quote. The court then explained that even if juror selection is considered a quote, judicial act, end quote, the judge had a legal duty to obey the criminal laws. Quote, but if the selection of jurors could be considered in any case a judicial act, can the act charged against the petitioner be considered such when he acted outside of his authority and in direct violation of the spirit of the state statute? That statute gave him no authority when selecting jurors, from whom a panel might be drawn for a circuit court, to exclude all colored men merely because they were colored. Such an exclusion was not left within the limits of his discretion. It is idle, therefore, to say that the act of Congress is unconstitutional because it inflicts penalties upon state judges for their judicial action. It does no such thing. End quote. Id at 348 TAC 49, emphasis added. Reference 6. The court's reference to, quote, the state statute, end quote, is to the Virginia law charging the county judge with the duty to select jurors in the circuit and county courts. Ex parte Virginia 100 U.S. at 340.